Well, thank you for joining us for the second paper. As we described earlier today, Voices for Liberty initiative has been soliciting paper proposals and selecting papers to support for publication. Our thought is that we'd love to see new academic scholarship on questions that relate to free speech, but that take up some new interesting questions. So that is what we are working on today. I'm Debbie Gatte. I'm the Initiative Director for Voices for Liberty. Delighted to be working with such a strong group of academics and paper authors and discussants here for the symposium.
Well, that's good because I'm not in the first group.
You're not in the first group? Self-deprecation. Okay, so Nicholas Mosvik is the paper author for our second paper. We've got the full title up here, but it's basically Free Speech for All or None, and we'll be talking about the abolition period. Nicholas is the Buckley Legacy Project Manager at the National Review Institute and previously a Senior Fellow at the National Constitution Center. He got his PhD in U.S. History from the University of Mississippi, JD and MA Legal History from the University of Virginia, and his BA from Minnesota. His research focuses on the constitutional history of the American Civil War, the use of English common law in originalism, and understudied justices in Supreme Court history. He lives in Downingtown, Pennsylvania with his wife, Lindsay, and two sons, Connor and Lincoln. Thank you, Nick, for being part of the program. Kathleen Brown. Kathleen is the David Boies Professor of History at the University of Pennsylvania, where she's also faculty affiliate of Africana Studies, the History and Sociology of Science, and the Center for Research on Feminist, Queer, and Transgender Studies, and the lead faculty historian on the Pen and Slavery Project. She's the author of two prize-winning books, but most importantly, her most recent book, which she has with her, Undoing Slavery, Bodies, Race, and Rights in the Age of Abolition, considers how the campaign to end slavery entangled activists in a complex process of undoing longstanding practices and habits of the body central to that institution. And the book incorporates research in legal and medical history to provide a historical understanding of the human body at the center of the debates about Black citizenship and regulations of Black people's movements, labor, and reproductive capacity. So that book is brand new, and I know Kathleen would love to talk about her book offline. Yes. And then finally, Mark Graber is the Regents Professor at the University of Maryland Carey School of Law. He is the author of too many books and articles. The most recent, which is Punish Treason, Reward Loyalty, the Forgotten Goals of Constitutional Reform After the Civil War. And he was given a Lifetime Achievement Award by the Law and Court section of the American Political Science Association. So that is our very esteemed panel today. The way we will work this panel, similar to the last one, Nicholas will provide about a 5-minute overview of his paper. We will hear comments from both Kathleen and Mark on the paper. We'll then move to a moderated discussion for about 15 minutes or so, and then open up for questions from all of you. So please get those questions going and think of them as you listen. All right, so Nicholas, I'll turn it over to you.
All right, thank you. And thank you all for being here, and thank you to the Law and Liberty Center for inviting me, having me be part of this initiative. I'm going to try to keep my comments below 5 minutes so that both my esteemed commentators have more time to give their remarks. So, as Debbie said, my paper focuses on free speech during the American Civil War, and particularly two groups who were minorities in different sense. That had their speech suppressed or claimed that they had their speech suppressed. And those groups are Democrats, who were the primary opponents of the Lincoln administration and the Republican majority in Congress, and abolitionists, who, of course, during the Civil War are still very active because there's an ongoing fight over what the proper aims of the war should be, what the conduct should be, how it should be carried out. And so that that's the subject of my paper. The episode that I focus on a lot has to do with one of the primary ringleaders of the oppositional Democrats, a man by the name of Clement Vallandigham, who was an Ohio congressman, and he was known as a Southern sympathizer, a sympathizer of slavery, and a Copperhead, which was the term that Republicans gave to their most radical Democratic opponents, Copperheads being like the snake. And Vallandigham had given a anti-war speech in May of 1863 in the Department of Ohio. So you keep in mind, during the American Civil War, there's all these districts in the North that have been overturned to military departments. They've made departments under military commanders with military courts. And why has this happened? Well, President Lincoln has suspended habeas corpus. There's a genuine fear of not just discontent in the North, but the kind of sympathy for the South that would actually lead to undermining the war effort and might actually be treasonous activities. So Vallandigham is in the Department of Ohio. The commander of that department is General Burnside, who had previously been better known not just for his facial sideburns, but for the defeat of the Union Army at Fredericksburg. Well, now he's commander of the Department of Ohio. Vallandigham gives this inflammatory speech, and he's arrested. He's quickly put on trial before a military court, and he's found guilty. And within a couple weeks, President Lincoln ends up suspending that sentence, but ultimately sending Vallandigham to the Confederacy, to the South. He's banished. And that sets off a series of debates between Democrats and Republicans in the press, in particular, in speech, otherwise, in public, about the fairness of this activity. Lincoln himself will give public letters that address this controversy, not just the suspension of habeas corpus, but his treatment of Vallandigham. And Lincoln's basic response to that is that, well, it's not just this one speech. It's his greater character. This is a man who truly sympathized with the South and wanted the North to lose, and therefore, I can argue in favor of what has happened here, right? So that's the central episode that animates my draft. And what that gets at, what that highlights within the paper, is a couple of things, which one is how both sides of this partisan divide felt that there was unfairness on the other side in terms of how they upheld free speech principles, how they dealt with free speech. And for Democrats in particular, the sense that Republicans treated their political dissent, their political speech, different from that of abolitionists. And I'll say one other thing, because we're at the close of time, which is that the other important aspect to this paper, I think, is that there's also a difference between what the government does and what private actors do, right? That's where that title mobs comes in my paper, right? What happens when you have a private mob that suppresses speech, and what happens if the government does something about it sometimes, but not other times.
Thank you, Nicholas. Kathleen.
Okay, my thanks to all who arranged this symposium and for your kind invitation to participate. And Debbie has frightened me about the time being strictly, so I'm just going to dive right in. I want to start by commending Nicholas for thinking historically about free speech and seeking answers in the 19th century. I like much of what you've tried to do in your paper, although I have a wish list for revisions. I wish you had embedded your account of the Civil War free speech conflict in the larger historical context out of which it emerged. Indeed, What you describe here in your paper served as a culminating episode of a 5 decades-long political and often violent conflict, not just over the rights of abolitionists to speak and publish against slavery, but over the liberties of free Black people more generally to inhabit their homes, defend their neighborhoods with firefighting equipment, and build civic institutions like schools, churches, and orphanages unmolested by white mobs that saw Black residence and institution building as a threat. I fear that accepting at face value the political battles of Democrats and Republicans during the Civil War as a case study of the fragility of free speech and the capriciousness of its advocates is to accept their radical decontextualization of the stakes in ways that ultimately distort the history. What if we widen the context? Abolitionists, white and Black, suffered violence against their persons, arson attacks, destruction of property, and terrorist threats on their families and neighborhoods sporadically between the 18-teens and the outbreak of the Civil War, and with great intensity during the 1830s and 1840s. It wasn't simply a matter of being unable to challenge the legality of slavery in Congress because of the gag rule from 1836 to 1844, which Nicholas acknowledges in his paper, but of acts of pointed destruction aimed both to prevent abolitionists from communicating with a wider public and to obstruct the civil liberties of free Black people. One dramatic example was the destruction of Philadelphia's Pennsylvania Hall in 1838, built for the express purpose of providing a public forum for reformist speech, and burned to the ground within 2 days of its opening by an angry white mob, tacitly supported by the city's mayor. In instances like these, when a governing authority winks at the mob, the distinction between government and mob suppression of free speech becomes less meaningful, I would argue. The long abolitionist struggle also featured the eruption of violence when Black celebrants marked the anniversary of Jamaican emancipation at a Philadelphia parade in August 1842. Looking only to the 1850s to provide context for Civil War speech suppression is not sufficient, because in that decade of crisis following the 1850 passage of the Fugitive Slave Law, refugees from slavery and their abolitionist allies found themselves embroiled in the dangerous work of facilitating slave escapes through clandestine networks and litigating against misidentifications or recaptures of refugees. Free speech was not the main concern of abolitionist activists during the 1850s, when the basic liberties, safety, and health of Black people and the rights of northern states to resist federal agents and federal laws were at stake. Many activists felt that the time for speeches had passed and the time for militant action was upon them. Even within the narrow chronological bounds of Nicholas's story, there seems to be much more at stake. I want Nicholas to tell us more about Vallandigham's stint as editor of the Copperhead Dayton Empire and his position on free speech issues at this earlier point in his life. I want to know about the impact upon abolitionist Congressman Owen Lovejoy, who comes up in Nicholas's paper, the impact upon Owen Lovejoy of an anti-abolitionist mob's murder in 1837 of his brother, abolitionist newspaper editor Elijah Lovejoy. How would Owen Lovejoy have framed the chronology of battles over free speech? Would he have seen the fight as limited to the Civil War? By the time we get to the charges of property destruction in Pennsylvania's Huntington County in 1863, there is just so much water under the bridge. The eruption of free speech conflicts during the Civil War was not an anomalous resurgence of an older episode of free speech suppression from the 1830s, but the culmination of a decades-long struggle by abolitionist activists, many of whom were old and weary by the time war broke out. The trading of accusations by Democrats and Republicans that Nicholas describes was the privileged battleground of well-educated white men who risked criminal sanction at a time when their contemporaries, white and Black, were being cut down by bloody warfare, rampant disease, and brutal draft riot violence. To decontextualize the Civil War free speech conflict from this large and longer context of violence seems to me similar to focusing on the flat rock at the top of Mount Everest without acknowledging that there is a steep climb to get there, and abolitionists in this case brought the fight. Nicholas has great material with which to contextualize his historical subjects and to analyze their investments in free speech over many decades. I hope that we can all convince you to do so.
Thank you, Kathleen. Mark?
I'm deeply worried that halfway through my thank yous, I'm going to get a note saying you should be finishing up now. So thank you to all. This is an excellent and surprising paper. The excellence, I think Nicholas has already demonstrated. The surprise for me is I sign up for a program that says, the contribution free speech has made to progress. And I get a paper on Republican suppression of Democrats, and one might say this would be a very good paper for a conference on the contribution suppression has made to progress. If you think that, in fact, maybe Republicans suppressing Democrats during the Civil War mattered. Now, there is a moral where Nicholas points out quite correctly that while both Democrats and Republicans suppressed speech, they each maintained a commitment to the general value of free speech. But one might note, one can rephrase that as, while both Democrats and Republicans said they were committed to free speech, when they had power, they suppressed the other's speech, and they gave reasons for doing so. And there is no broader lesson to be learned up here where we have to ask ourselves, and the paper doesn't ask that question because the paper doesn't ask a lot of questions because it's a 20-page paper and there are only so many things you can do. But the question is, well, was one of them right? Maybe one was right and the other was wrong. But I do want to suggest, as the project goes further, to ask some finer questions. It's too easy, and we see we do it nowadays, to say everybody suppresses, because there are anecdotes of everybody suppressing. So, for example, if there is one stupid teacher in each of the 50 states who does something with free speech that is utterly reprehensible, we have 50 anecdotes. And that's going to fill the papers, but it's one in every state. So what we need to know is a little more, once again, a different kind of context, that how often did this occur? In particular, we might want to compare the North and the South, and what I think we will discover is the North is an imperfect democratic state. By this I mean there are elections, there is relative free speech, but it is true that in most areas of the country, one position has advantages, undeserved, the other doesn't. Some people find it easier to vote than others. But it is the case that most people, most of the time, are aware of the arguments on both sides of the question. Witness the Lincoln-Douglas debates. What we are likely to find in the South is a more totalitarian regime. And here, I think we've lost the meaning of totalitarian. I see when A represses the speech of B, someone says, aha, it's totalitarian. Florida is a totalitarian regime because, in fact, they're restricting certain speech in schools that I firmly believe, by the way, they shouldn't restrict. But notice a difference. A totalitarian regime doesn't simply restrict speech here. It's called totalitarian because it seeks to restrict speech in all places. Not simply you can't say this in school, but you can't say this in a private school, you can't say this at home, you can't say this in your religious assembly, you can't say this in this speech. What we're likely to see is the North was a substantially more open society than the South, and the North gained the benefits. In particular, the North was scientifically more advanced than the South, and the victory of the Civil War that succeeds in freeing the slaves is a victory of the virtue of an open society versus a closed society, even as we can demonstrate that this open society was imperfectly democratic by any standards we might want to apply. I beat you to it.
Well, thank you very much for your comments. And there was a phrase that Kathleen used that I think I heard reflected in Mark's comments as well, which is this decontextualized paper. And Nicholas, you were nodding when you heard that. So the paper does focus on suppression of speech during the Civil War, right? And wartime is a special set of conditions. It can be an easy excuse for suspending free speech and other civil rights. But prior to the Civil War, in the 1850s and earlier, right, the need for this same speech was present. And I'm wondering what you have to say about the climate and conditions. What was that like for people who were speaking on abolition, dissolution, secession, all the controversies? Give us some of the context, Nicholas, and then I know Kathleen and Mark, you probably have more to say about the contextualizing of the paper, so let's spend some
We're
time on that.
academics, we always have more to
Oh.
say.
Yeah, well, that's true. It's part of the nodding is that it's always important, and it's always something that's going to come up. So it's partially my own awareness, which is when you're still in progress and you're still working on the paper and fleshing it out, fleshing out what you're going to do, sometimes you lose some of this wider context. But I was partially nodding because I know all those episodes. Those are all important episodes, particularly in Philadelphia. I think, a good amount of my sources come from this area. It's not even the only relevant riots. There's the Christiana riot in 1851, for instance, which was rather important. It also leads to an important Pennsylvania court decision. So there is a lot going on in the decades leading up to it. So if you do take that wider lens, you zoom out a bit, which I think the paper has to do upon completion, there certainly is that's an important aspect of understanding how we get there in the 1860s. And I think that's the other aspect of my approach, which I do and other scholarship I'm working on, which is to say that these constitutional positions of the relative sides, they weren't like invented in 1862, but rather were the product of decades of, I call it Jacksonian constitutionalism because I think it's really framed in that period of time, but you could put it a different way because you could just link it even to the abolitionist debates. You could do that as well, or I would say you could frame it around reactions to John Marshall, the Marshall Court. Were you pro or anti-Marshall Court? These were really important positions in that time, and constitutional rhetoric, to me, is the vehicle by which public actors spoke about relevant, important political and partisan issues of their time. So that context, I think, is important, and the paper has to do more fleshing out to get there, and to make sense of, I think we talked about this last night, or this week when we had our Zoom discussion about this panel. Is when Wendell Phillips, the famous abolitionist, gets mobbed during the Civil War, it's not the first time he's been mobbed in his life. Right? I mean, William Garrison, rather, I think famously, almost lost his life more than once in the 1830s when immediate abolitionism first became a really prominent social movement. In the suppression of speech, it's not just the speech itself, of course. It's the assembly, it's the distribution of pamphlets in the South, it's not just the gag order, it's the Jacksonian administration, limiting what the post office can do in terms of delivering abolitionist mails. There's all these things that are happening, right, before we even get to that point, right? So there is this broader context of suppression. I think that that is certainly important and does need to be pointed out. So I take that in stride.
Comments accepted.
Yeah.
Kathleen and Mark, would you like to add some more to the context? I mean, you've started discussing that, but I know there's much more to say, so turn it over to you.
So I guess all I would say is I think I respectfully, partially disagree. I don't think that for the average free black resident of the North was anywhere near an open society, although clearly the apparatus for controlling communication and speech was much tighter and more all-consuming in the South. So I partially agree, and what I would say is I think abolitionists made it a fight. They weren't fighting on behalf of free speech. They were fighting on behalf of their right to actually broadcast anti-slavery, an anti-slavery message. So they fought, tooth and nail along the way. Now, by the 1850s, is it true that they've had some success? Yes. But there are a lot of bodies strewn along the way. So that's, and so I'm glad to hear you say something about the broader, longer context. Yeah, I guess it's more, of course, as the person who's not a legal scholar per se, but a historian, I think the long view is going to be important. But I also think the long view gets other actors into your account that actually made free speech matter as a conflict. Like they brought it to the point where there were some of those debates. And so that's more my concern, that it not end up being such a more narrowly focused on these groups who are having the fight in the name of free speech. You're absolutely right. They are doing it, and that's actually the strength of what you're doing. But I think how it actually got to be a fight about free speech in the name of free speech is a really crucial part of the story.
Well, always the great danger of saying you need more context is there's an infinite number of contexts. And I mean, one notion of this paper might be is I'm going to tell a story, and other people can figure out the context, and that's perfectly legitimate. But if we want a couple of contexts, here's where we're not in big disagreement. We're more modifying each other. So I want to accept wholeheartedly that African Americans, by the way, women, other groups, they're in this open society. I said there are pockets and there are shades. There simply are, there are pockets and shades rather than in some sense in the South on this issue, it's all one color. That's all I want to say. But here is another nuance that I think we'll agree on. I like to make the distinction between abolitionists who believe what is wrong with slavery is the violation of the rights of African Americans, and a certain anti-slavery, which Lincoln makes his primary appeal to, which is a major thing that is wrong with slavery, is the violation of the rights of white men. So this is the slave power. The reason we don't have a tariff, the reason we don't have internal improvements are these people down here. And it's one thing to enslave African Americans, but when you violate the rights of white men who criticize that, well, that's a problem. So I think the free speech, you're right, plays more on it's white men's rights being violated than on the abolition, what's wrong with slavery, is that slaves don't have free speech. No, that's the least of the slave's problem. Yeah,
Yeah.
so I think, as I said, we're building on each other
We
rather
are.
than disagreeing.
We are.
Do you want me to
Yep.
say something quickly about that? Yeah, I mean, I think there's something to be said, too, of free speech in this case being a tool for broader movements or broader divides. I think even in the context of the Civil War, in this particular Republican-Democrat divide, and I had this in my comments, but 5 minutes, we don't get to all these things, is there's a bigger constitutional fight happening here, right? Which is this sense amongst the dissenting Democrats that you're creating Leviathan, right? They call it the road to despotism, right? These are the words that they use. It's latitudinarianism. It's destruction of the Constitution, right? It's not just the right to free speech. It's assembly. It's Sixth Amendment right to trial by jury, right? If you're in a military trial, you've lost your proper right to trial by jury among your peers in the place in which a crime was committed. They had complaints about their Fourth Amendment rights being violated. They had a litany, in other words, of what they believed to be civil liberties violations that added up to this war is really a design to destroy the Constitution as we know it, right? That's one side. The other side is, I think Lincoln probably puts it best himself, which is, well, the Constitution has to have a mechanism to save itself, okay? Because that's what the context of a civil war is that there's a group of people who would prefer to actually destroy that Constitution. They're actively trying to do that now by destroying the Union and creating a separate republic, which we don't recognize the legitimacy of, whose sole basis is the right to own other human beings. So I think that is, there's an important broader context there within just the Civil War itself. But then I think even when you back up, that's true as well.
Okay, so one more question up here, and then we will turn to the Q&A with all of you. So Nicholas, the very last line in your current draft, which may or may not change, but the current last line is, in a time in which threats of renewed civil war, even that of nonviolent cold civil war, and a rising political feeling that power is more important than rule of law, this history is a reminder of the stakes of constitutional politics. So that's the current last line of your paper. Can you tell us a little bit more what you mean by this and what your readers will take away? And I'm thinking also something that Mark said, which is the theme of the Voices for Liberty initiative is about free speech, civil rights, and social progress. So if you could tie it a little to social progress as well, I think that would be helpful.
Yeah, so I've been trying to think about the latter as well, because I think that's an important thing to address. But in terms of that final line, I'm sure the final draft will look a little different. Rhetoric always changes, but in this case, I was trying to signal, I think, at least to me, the obvious current import of this history, which is from time to time, the Civil War becomes more interesting in public discourse, either because an anniversary is coming up, or people have a sense that the divides are so great in this country that we could fall into that sort of violent struggle again. Although one might argue that it's actually more analogous to the antebellum period than the actual Civil War, right? In the sense of various violence, outbreaks, mobs, things like that, right? So that was less to take a position on the particulars, especially our current political divide and crisis, and more to say that people are thinking about that. And so I want to make recognition. I understand people are thinking about that. One of the most important things that history can do is both to provide a sense of possible parallels, but also be careful that the past is unique as well, right? The past is a foreign country. The way that people thought about these things 160 years ago is not exactly the way we think about things now. And what would cause such a struggle is not necessarily the same thing either, right? So we always want to be a little bit careful about that. In terms of progress, I think it's really interesting that Mark brought up whether or not suppression itself possibly can be its own form of progress. I think there may be something to that, in the sense that if you take Lincoln's position, which I think one of the really important things that happens in this period of time, and you alluded to it, and I'd like to highlight it more in the final paper, because it's always struck me about Lincoln, it's what drew me to greater respect for him in some ways, is that during the Civil War, he takes time to write public and private letters addressing his political enemies and to make serious constitutional arguments in favor of his position while recognizing he understands the other side. I think that there's something sort of incredible about that, because that does suggest that the North is of a different character than the South. Jefferson Davis does not do this. Jefferson Davis tells his Attorney General and everybody else that, hey, whatever he says, that's the law. And yeah, if you want to report on your neighbor because they're saying disloyal sentiments about the Confederacy, we'd like to hear it. We'll send out the Home Guard. So it's very true that that happens in the South. I think one of the reasons, personally, I'm less drawn to studying what happens in the South is because it's so much more obviously total in its suppression, right? Whereas in the North, there is more nuance, right? Because there's on one side, there's the claims that are actively being made, but then there's the reality behind them, right? How much was truly suppressed? So I think it was good that you brought that up as well. But I think that is a question I'm going to ponder more and more, is whether or not that is a way of articulating the sort of progress that comes out of the Civil War.
Thanks. Kathleen and Mark, is there anything you want to add about the warning signs from this historical account that you see reflected today?
No, but I just want to say, I think that belongs in your paper, what you just said. No, I'm really serious.
I wish I'd written it down.
Well,
It's
you got a lot.
It's recorded, okay.
Yeah, a lot of witnesses here who can help you work that one out.
Mark, any thoughts?
I always worry that people who remember history are condemned to repeat it. I think Santayana may have gotten it exactly backwards. That, otherwise known as, this is the French being prepared to fight the last war perfectly. But I'm not sure what free speech per se has to do. My own feature is one common feature of repression is a notion that this is unreasonable speech, that, that there is no virtue in John Stuart Mill's claim that even 1 + 1 = 3 has a value. And whether that's true or not, we see in both time periods speech that was considered reasonable by substantial groups of the population, including substantial groups of the educated population, was treated as unreasonable by others. And one finds in our time the boundaries of reasonable speech on all sides continue to shrink, and that may be a problem.
All right, thank you, Mark. Let's turn to questions from the audience. Please wait for Amanda or Tim to reach you with the mic so that everyone on the live stream can hear it as well. Over here. And please introduce yourselves. Thank you.
Yeah, hi, my name's Andy Hawks. I'm a local attorney. How are these First Amendment battles playing out in the courts during the Civil War? I note that Nicholas made a reference to a Pennsylvania case that I'd like to hear more about.
So that wasn't during the Civil War, just to be clear. I was referencing a case from 1851 that has to do with what's known as the Christiana Riot, which happened near the border of Maryland. So I'm trying to do this all from recall, so I may get some of the facts wrong. But essentially, a Maryland slave owner crossed the border with a group of men to try to reclaim a family that he had claimed as his property. So this is under the Fugitive Slave Act. And they fought back. And a group of local abolitionists helped. They were armed. The slave owner ended up getting shot and killed. And therefore, that's how it ended up in the courts. So it's something that you can look up, and because every year it seems to get even better and even easier to find some of these old court cases. So if you go to Case Law, which has a great database of old cases, including the state reports. So here, the Pennsylvania State Reporter, you can find it. I came across it because a judge on the Pennsylvania State Supreme Court, which I studied for my dissertation and Welby first book, was part of that case. And so that piqued my curiosity. But that was just an example of a notable episode. It was a court case, but it's also not just a court case, right? Because I think that's part of my larger theme here, and I heard this in the first panel too, which is it's very easy, especially in, I think, legal academia, to privilege the status of the Supreme Court. However, one thing this history does for us, I think that is helpful, is it takes us away from just thinking about what the Supreme Court did. Because the Supreme Court didn't rule on First Amendment challenges during the American Civil War. Now, there are habeas cases. There's the military court case related to Vallandigham, which I brought up in my introductory comments. Federal Judge Leavitt, who upheld his conviction. That's an interesting case worth reading. And the Supreme Court does act after the Civil War regarding civil liberties and military courts. And that's Ex parte Milligan, which is also worth reading and considering. I'm just making a note that that's a case that's subsequent to the Civil War when it's decided, although the events of the case come from during the Civil War. It has to do with so-called copperheads. I say that not because they weren't necessarily copperheads, just that that was a term given by Republicans to what they also would call peace Democrats. That is, those Democrats that wanted immediate peace with the South. In Indiana, who were arrested and tried by a military tribunal.
Mark, anything you want to add about the courts during this period and what they were doing?
Yeah, did I get anything? Let me know if I got anything wrong there.
By coincidence, a good deal of my research the last 2 weeks has been in a case called United States versus Hanway, which is the case you're referring to. It is particularly important because it gives a definition of treason and insurrection, which is the understanding at the time the Civil War is, and it is broad, and it encompasses speech. And when I've talked about this, every originalist has basically said, well, we're not going to be originalist on that one because you don't like their notions of speech. For better or worse, the federal courts had a commitment during the Civil War, which was avoiding resolving anything they could. There's an amazing amount of bad law on jurisdiction that got reversed immediately after the Civil War because the court would invent a jurisdictional excuse for not hearing a case. Then in 1867, someone would say no jurisdiction because of that and said, oh, we just made a mistake. So there is a district court case on Milligan, which, by the way, if you read the argument for Vallandigham, it is the most pro-civil liberties argument you'll ever read in American history. Needless to say, that's not where the federal district court came out, and the Supreme Court invented a jurisdictional excuse for not hearing the case.
Which, by the way, is that's in my other research. I found the same thing. So I do conscription during the Civil War, otherwise, but it's entirely the same thing. Most of the interesting cases are at the state court level. The Supreme Court wants nothing to do with it, even though Chief Justice Taney, he wrote secret opinions regarding conscription and the income tax that he kept in his personal papers. So he may have wanted to rule, but most of his colleagues did not. And more importantly, the Lincoln administration was telling the Justice Department, don't recognize the jurisdiction. Just, and there's a legal historian who's written about this. I'm trying to, now I'm blanking on her name. She's at UVA. Cynthia Nicoletti.
Cynthia Nicoletti.
Yeah, and she's written basically that what this is proof of, and she talks about the treason trial of Jefferson Davis, is that during the Civil War, the Lincoln administration was basically saying these constitutional issues are going to be resolved by the war itself. If we win, then that's actually the important thing. It's not going to be resolved by the courts. So it's sort of a strategy of avoidance, if you will.
Kathleen?
No, all I was going to say was to pile on with the Hanway. Hanway in the case was a white miller living in Christiana who was charged with treason mistakenly as the ringleader of the
Yep,
whole
yep,
operation. And was your previous work on Greer or on Kane?
So Greer I looked at because Greer's was from Pennsylvania. So
Dickinson College.
Dickinson College, just like Taney,
Yep.
which is, and Buchanan. Buchanan famously wrote a private letter to Justice Greer in March 1857 to get him to join the Dred Scott majority because they had all been at Dickinson College.
Right.
So, but Greer came up because Greer was on circuit in Pennsylvania. And Pennsylvania is the one state in which the state Supreme Court overturned conscription is unconstitutional. And yeah, that was Greer's circuit. So that was my interest in Greer.
Okay,
Yeah.
interesting.
Additional questions?
So obviously, one of the themes of this paper is that everyone pays lip service to free speech until they're in power, and then they suppress the other side, right? And so my question is there anything from this part of our history that either shows any inkling of an example of people sort of trying to grope their way toward a principled, consistent notion of free speech, or any way in which you can use this service, press this history into service to try to construct such an argument that one can use, today, trying to get, because of course things haven't really changed all that. Well, I think we've gotten better actually to some extent, but still, it's very clearly the case that there are, people who talk a lot about free speech when they're actually wielding their own power, seem to be finding lots of exceptions to it. And does this history give us any help in trying to persuade those people to be more consistent?
Do you want me to take that first?
Yeah, go for it.
Yeah. It's not in the paper, but when you asked your question, I thought of there's a cabinet meeting in September 1863. We know this because, he would become Chief Justice Salmon Chase, but he had a diary during the Civil War. You can read it. It's a great primary source, although he's not the only cabinet member who kept a diary. And we know there was great disagreement over the suspension of habeas corpus, which was resuspended in September of 1863. It had first been initially suspended at the beginning of the Civil War. Then Congress acted and was suspended again in September 1862, and then in September 1863. And Chase was opposed. So I point that out as an example of, Chase might be an example of somebody who understood the motives of those who wanted to suppress more, but wasn't sure whether or not it was proper or constitutional. And the reason why that's of some note is, he's Chief Justice when Milligan comes to the court. And there is a divide between the court, 5-4. So he writes a partial dissent in that case. But I would say Chase might look consistent in that regard. And I think it's also what makes Lincoln's public letters interesting, because Lincoln, in my estimation, writes in a way of saying, I understand and respect these civil liberty concerns from the other side, but I think in this particular context of civil war, in which some of these threats are legitimate, in which someone like Vallandigham, it's not that he just gave an anti-war speech, it's that he has voted and acted for years as someone who doesn't seem to be genuinely interested in this country winning the Civil War. He seems to want to act to aid the enemy in a seditious manner. So I think you can find, it's not simply, in other words, it's not simply a matter of rote power, but of course, there also is a lot of hypocrisy, and there's a lot of charges of hypocrisy, right? That notion from both sides of, you like some speech but not others, and it just depends on whether or not you favor it. So I think that happens a lot, but there is some instances of, I think, genuine consistency in principles.
I think this is where context matters. Free speech, freedom of religion, racial equality, guns are what I like to call eternally contested concepts. It's not that when one side wins, the problem goes away. If we move to, say, a more free speech, there'll be new problems upon which people will disagree. So what strikes me as relevant is something I said earlier, I really want to reemphasize. The debate in the Union was at a very different place than the debate in the Confederacy. The debate in the Confederacy really is, it's not even a debate, it's a totalitarian society. For Lincoln, it's really how close to the troops is this speech? That is, Republicans are debating, say, if this is the area, this is totalitarianism, this is, say, your dream free speech society. Republicans are debating over here. Confederates are talking over here. And to say both are suppressing speech misses the more fundamental question of what speech is. So to take a simple example, one I've had a conversation before, I'm Jewish, and people say it's a really rough time, for Jews on campus. Yeah, but it's not Nazi Germany. The debate is here, not here.
Kathleen?
Yeah, just add one thing. Oh, and I just lost my point. I was fascinated by what you just said. It'll come back to me.
Okay, all right. I think we have one question over here.
So, this discussion led me to think, well, what is the next best example of a situation where the government was tempted during a major war to suppress speech? And the obvious answer is World War I. And World War I was taking place in Europe, obviously. There was no real threat to the American Republic the way, or our constitutional system the way the Civil War was. Yet it does seem to me that the Wilson administration was much worse about locking up people and suppressing newspapers than even the example than what we give for Lincoln, which is kind of interesting. So so if you put it in that you compare the Confederacy on one side, Wilson on the other side, then like Lincoln winds up looking pretty good. And maybe the theme is actually the fact that there was this, the ideological background of the Republican Party abolitionism did have these natural rights and so forth impulses that may have actually strongly mitigated their temptation to be authoritarian or totalitarian in the middle of war. And, it's fascinating that Chase, for example, who more or less, if not invented, publicized the idea that the Due Process Clause barred slavery in the territories. And he's like, but you can let people speak. So that's one thing I wanted one point I wanted to get at. The other point, which is a little bit far afield from your paper, but I thought since Mark raised this, one advantage of free speech, we look back at abolitionism and its allies and say, well, the really good guys were people who cared about African Americans and their rights, and there are these other broader group probably who were brought onto the cause or supported the Union or whatever because they were worried about themselves as white people, that the slave power is going to oppress everybody. After Dred Scott, they were going to have slavery throughout the country, and white workers would be enslaved. Now, on the one hand, we could look back and say, well, they were not as morally advanced and perspicacious as those who were concerned about African Americans. But on the other hand, this is how you win, right? If you're a small oppressed minority, that especially one like slaves that don't have a vote. Most you, look, I tell my students when we talk about this stuff in Common Law 1, you live in the North, you live in Massachusetts, you may never see a slave. You probably never travel to the South. You may never leave, more than 20 kilometers or whatever from your house. Why do you care what's going on there? It's, we don't care what's going on in China now for the most part. I don't care what's going on in China particularly, right? I don't follow it very closely. I know a lot more about what's going on in China. I have a lot more access to China. I could fly there in 12 hours than someone had to get to Georgia from from Maine or whatever. So I don't think it's necessarily like saying, oh, so there's this moralistic tendency to say, well, they weren't really favoring the right people. They were worried about themselves. And people are generally mostly concerned about whatever they consider their own group. So one advantage of one thing that abolitionism was able to do was to say, even if you're not worried about those folks, worry about the implications for your own freedom, and that's how you wind up getting enough allies to win.
Could I just respond quickly?
Yes, please.
So just a couple things not to forget. So there still are people who are lingering in slavery, very small numbers, in New Jersey, right? All the way up to the end of the antebellum period. There also are black abolitionists. So when we talk about abolitionists, we should not just dump everybody into the white person category. And then I did remember my other point, and that is that the abolitionists have succeeded to some degree, if your paper is a measure, in making people feel that certain kinds of speech in defense of slavery is unreasonable, to go back to your point about reasonableness. And so they're not advocating for free speech until the point that they're at the top of Mount Everest. They're never advocating for free speech. They're advocating against slavery, and they never expect they've got free speech. That's why they're building places to meet. There's no place to hold a gathering except a church, and the ministers won't let them into the churches. So just that there is also this war over, or a battle over, who is actually speaking reasonably. And that's a different kind of battle that we could argue free speech makes possible, right, to have that kind of argument. But in this case, this is people without any free speech. They never thought they were having it, but they were determined to get the message out. And then only a few of them, I think, get into an argument about free speech itself, as Nicholas's paper.
That's actually, just to mention quickly, because I think David mentioned Frederick Douglass, that reminds me, and this could be incorporated in the paper too, December 1860, there's a venue in Massachusetts, in Boston, for an abolitionist gathering, and a mob shuts it down. The police won't do anything about it. And Douglass shows up the next Saturday and gives a great oration in defense of the principles of free speech. It's kind of one of our great rhetorical defenses of the principles that we have in the 19th century, and it comes precisely out of this. Well, there's no venue, because the people who hold the venue, they don't want the mob there. They don't want to take the chance of someone getting killed, because it's a non-zero chance that someone will get killed, and the police don't want to get in the way because they know some of them might be sympathetic to the mob, but they also know what the mob's capable of. They don't necessarily want to take the danger because abolitionism isn't the majority position.
I would love your paper a lot more if you had that in it.
I'll add just in response to David's first part, and this is
The
a
Woodrow
dangerous
Wilson
assertion
problem?
to make in an academic conference. I'm deeply suspicious on a great many matters, whether much depends on the idea that exists way up here. Natural rights, liberty, what other thing? I think we find throughout history that the big idea up here turns out to have lesser effect on what goes on here than you would think, that it has much more to do with a certain sense of tolerance, which can be held by people who vastly disagree with what's up here. That's just simply my sense of the universe.
And that sets us up nicely for the rest of the day. So we are out of time, and thank you very much to Nicholas, Kathleen, and Mark for their comments. Can't wait to read the revised paper, and yes, we did record this, all the brilliant things that came out of you, Nicholas, and everyone else, you will have access to.
The unplanned things.
Yeah, the unplanned
That I would
things.
never remember
Right.
a minute later.
All right.
So.
That is the end of this panel. We are now going to move to our plenary session and lunch, which is across the hall where breakfast was. Our keynote speaker, Jonathan Rausch, will be offering his address at 12:30, followed by a brief Q&A. So now's time to stretch your legs, go across, get some food, and then we will resume at 12:30 with our keynote. Okay, thank you.
All right. Thank you very much.
Great.